Hey everybody, this is Christopher Small with CMS Law Firm. We do estate planning, we do probate, we do it well. Today, I wanted to talk to you about a question that I was asked today by a client and that I thought you all might be interested in. The question is, am I personally liable as the trustee for trust debts? And I'll explain this more in a minute, but if you have estate planning questions or probate questions, you need help with either of those, please go to estatemeeting.com. You can set up a time to talk to me in person or over the phone for free. estatemeeting.com. Cool. All right, so I had a client call me today. He created a trust, and there are some properties in this trust. The properties have mortgages on them, and he is worried that in the future, he personally is responsible for those mortgages, but he may not be able to pay them all himself if some circumstances happen. These properties are in the trust, and he wanted to know if he would be required to pay these mortgages if he couldn't afford them, or what he would do if he was the trustee of this trust and also then the personally responsible for these mortgages. And I told him that he would be able to sell the properties and liquidate the properties if he cannot afford those mortgages. Here's why. The trustee has a responsibility and a duty to make the trust property, the property that's inside the trust, to be as beneficial as possible for the beneficiaries. The trustee, even though it's the same person in this case, it could be different people and it would still be the same. If the trustee had knowledge that the property that was inside of the trust would be at risk to foreclosure or to other creditors because of the inability to pay the debts on the property, the trustee would be almost obligated to do something. And in this case, it would be to liquidate those properties, take the cash out that they could, and then reinvest it someplace else that was prudent and safe and would work for the trust. If he did not, and the debts then were not able to be paid, then those properties would go into foreclosure. They probably would be sold at a discount, and that would not be good for the trust. For that reason, if those properties were not able to be paid, those mortgages, it would be the responsibility of the trustee to do something about that, to not put trust property at risk. So if you find yourself in this situation and you're not sure what to do, that is the answer. Although it seems and makes sense, from a sort of a normal perspective, oftentimes the legal answer can be different. In this case, thankfully, it's not. You actually can do what's right, you can do what makes sense, and you would be able to keep that trust property, which is the equity in the house, safe and invested in some other vehicle that would be able to provide a return for the beneficiaries, would be able to keep the trust healthy and just do the thing. All right, so that is it. If you have any questions about this or anything else, or you think you need some estate planning help or probate help, please go to estatemeeting.com. Set up a time to talk with me over the phone or in person. estatemeeting.com. Once again, I'm Christopher Small. I'm the owner of CMS Law Firm. We do probate, we do estate planning, we do it well. Thank you for your time, and I will talk to you again.